Good morning, good evening, good afternoon, wherever you may be. My name is Chris Simmons, attorney at law, and the Supreme Court just denied writ of certiorari for the DACA case. Now, this was going to be over the injunction, which basically keeps the Trump administration from winding down the DACA program. They don't have to accept new DACA applicants, but they can't just blanket deny every reauthorization of DACA. They can do it on an individual basis, but not for everyone. And they have to keep the program alive while it's going through the courts. So that's what this is. This isn't anything groundbreaking. This isn't anything unexpected. The Supreme Court rarely, if ever, grants a writ of certiorari straight from the trial court. You normally do have to go through the appellate court. The Trump administration in this case was just simply trying to skip the appellate court, go straight to the Supreme Court. They didn't let it happen. Nothing controversial. I just thought we would explain what this is exactly and what the legal ramifications is. Basically, the Trump administration now has to take this to the appellate court. The appellate court will rule on it. The loser will probably appeal to the Supreme Court. Then the Supreme Court will grant or deny certiorari and either hear it or let the appellate ruling stand. What this also means is that while this is going through the appellate process, the injunction is in place and the Trump administration cannot wind down. Now, what happens when either side loses the appellate battle? They go to the Supreme Court and the Supreme Court rules one way or the other. Well, that's just on the injunction. It's not the substance of the case. The case still has to go forward, so even if the Supreme Court were to rule against the injunction, the case would still be live. Now, the problem here is that if the Supreme Court were to rule against this injunction, then the Trump administration could end and wind down the DACA program, and then there's a problem of, well, what kind of relief can really be granted? But I'm sure that they've already thought of that. The lawyers in charge of the University of California's side of the case have already thought of that. But that's one thing. Again, this is all over the injunction, not the substance of the case. This is expected. This is just an update on that, so I'll see you in the next video.